Trooper Charles Brooks, Charles, last of Brooks, Brooks.
What troop do you work for?
Currently, I work out of Troop D in Concord, formerly of Troop B out of Tamworth.
And what is your position within Troop D?
Just patrol trooper.
You mentioned that you were previously with Troop E. Did you have the same role there?
Yes.
And when did you work for Troop E?
From 2021 until March of this year.
So were you working there on December 17th of 2023?
Yes.
On that date, were you asked to assist in an investigation regarding the murder of a woman at 332 Water Village Road in Ossipee?
I was.
What was your role in that investigation?
So as a patrol trooper, I was asked to sit with the suspect at the time at the Troop E barracks, as he was in a capacity wasn't free to leave.
So at that point, the suspect was being detained and you were sitting with him at the station?
Correct.
Who was that suspect? What was his name?
The suspect was William Kelly.
Do you see Mr. Kelly here in the courtroom today?
I do, sit in the white shirt with the red tie at the defendant's table.
Ask the record reflect he's identified the defendant.
It will reflect.
So you mentioned your job was to sit with him in a conference room. Why would you need to sit with him there as he was being detained?
So the suspect had been advised of his Miranda warnings by Trooper Andres, and he had advised that he was not willing to speak to law enforcement without his court-appointed attorney. So at that point,
Yeah. Ladies and gentlemen, I'm going to direct you to disregard what the witness has just said.
Is it
Everybody
fair to,
clear on that? Okay.
Is it fair
Yeah,
to say
yeah.
that
I want to remind you, you were told at the very first day of jury instructions, I think you've been reminded since then, and you'll be reminded at the end of the case, that declining to speak to the police is something that the defendant had a right to do. You are not to consider his exercise of that right in any way, and again, I'll just remind you, you are to ignore what the witness has just, the last remark that the witness made. You are to strike that from your mind. It's not to play any role in your consideration of the case.
Counsel may proceed.
Is it fair to say that when someone is being detained at a police station or a state police barracks, they're not free to move about the station by themselves?
yes, and that was my purpose.
About how long did you sit with the defendant that day?
It was about 10 hours intermittently with breaks.
And when you say breaks, would you take breaks and go do other things at times?
Correct. Another trooper or detective would relieve me.
What is your standard uniform as a patrol trooper? Is it what you're wearing now?
Correct. What I'm wearing now currently.
Were you wearing that when you sat with the defendant?
Yes,
Does that include a body camera?
it does.
And was your body camera on and running on the 17th?
Correct. And the defendant was advised of that.
When you sat with the defendant over the course of those 10 hours, did he make conversation with you?
He did occasionally.
Would he ever reference Christine Falzell?
Yes.
In what way?
He would bring her up, ask, I don't recall exactly if he had been advised of her status at that point, but he would bring her up, and then he would also make references to his dog and the house.
Was he concerned about the dog and things going on at his house?
I would say, in my perspective, far more than he was about the girlfriend.
Okay, so when you say that, what was his demeanor like when he talked about the girlfriend, Christine?
Not super concerned. He was significantly more concerned about the dog.
One moment, Judge. That's all I have. Thank you.
All right, Trooper Brooks, some questions about your involvement in this incident. Do you understand?
Absolutely.
Okay. So it's sort of clear from your testimony, right? You weren't on the scene while he was there and she was declared dead in his presence.
Correct.
Okay. So you did sit with him, right? On this day?
Yes.
All right. And that is, you begin your shift what time?
Sometime before 2:30. So my normal schedule shift was supposed to start at 2:30. I think I was called out early, if I recall correctly, for this.
Okay, because it's a night shift that you were supposed to be serving?
Correct.
Okay. And so somewhere around 2:30, and you understand that the police involvement in this incident began around noon of that day?
Yes.
Okay. And you say you sat with him for maybe 10 hours from when you first met with Mr. Kelly, right?
It was approximately 10 hours, like I said, with the breaks.
Okay. So regardless of what the jury finds about his responsibility, this is a man you're sitting with who has been at least awake since noon. We know that, right? Say it out loud.
Yes.
Who has been through a traumatic incident, fair to say?
Fair to say.
Okay. Has tried to save somebody's life and failed?
I don't know to that.
You don't know about that part of it?
Yeah.
Okay.
I'm not.
And been taken into police custody and told he's not going to be let go.
Correct. At that
Okay.
point in time, I was advised that he was in police custody, not free to leave.
All right. So you're sitting with him, and you're telling this jury that you're concerned that he is expressing emotion over his dog, right?
Yes.
Okay. So when you first talked about your role as a police officer, you said, "I'm just a patrol trooper."
Correct.
Okay. And you know it's important to be a trooper.
Absolutely.
Okay. But there are certain things you're just not, right? Certain expertise you just don't have, right?
Correct.
Okay. So do you have expertise in grief counseling and therapy?
I do not.
Okay. Do you have experience or expertise in psychology?
I do not.
Do you have expertise or knowledge in social work?
No.
Do you have knowledge or expertise in running a support group or a grief recovery?
I do not.
Okay. Do you have any idea how he's supposed to act after that type of traumatic incident?
Not from a clinical standpoint, no.
What's the spot for?
Just sitting here.
Thank you. Trooper, your testimony is all complete. You may step down.
Thank you, Your Honor.
State next calls Mallory the witness.
Again, for a mistrial in this case. Trooper Brooks. Thank you. Trooper Brooks indicated in this case that Mr. Kelly invoked his right to remain silent. I don't believe the state acted in bad faith here in intentionally eliciting that response at all.
Yep.
I do think, however, that this is an experienced trooper who made a statement which we are all aware is verboten in U.S. constitutional law. He indicated that in a custodial setting, Mr. Kelly invoked his right to remain silent. This becomes doubly problematic in this case, where I believe that its cumulative effect creates an additional manifest necessity for a mistrial, on top of Your Honor's adverse ruling allowing the state to comment on the invocation of silence to what Your Honor has deemed to be private parties over our objection with the emergency medical personnel in this case. And I think it manifests this way, right? There's the commonsensical understanding of, okay, piling on invocations here. And I think we have the uncontested understanding of all of us that a law enforcement officer in uniform on the stand talking about in the hours preceding a violent death, someone invoking their constitutional rights, is something which is incredibly impactful when a jury hears it. But that is on top of the state making a feature of their case, Mr. Kelly's invocation of rights, and using that quote, invocation. Okay? He invoked, and Attorney Hinckley paused, went back, and had the witness emphasize that he used the word invoked. So this is, as you...
My recollection was that the word was incriminating, not invoked. I could be mistaken on that, but that's what not invocation, but it was, yeah.
Thank you.
That incriminate was the word that he used, yeah.
I appreciate that, thank you.
Yep.
To incriminate myself. And again, the formal trappings in the use of that word are doubly problematic, because I'd like Your Honor to consider it, and for everybody to consider how this plays out when Your Honor reads the jury instructions, right? So we've got this situation where the defense has indicated along, and even prior to here, move for a mistrial based on the negative effect of that first to emergency personnel refusal to speak. But now you've got a law enforcement officer doing it. And Your Honor correctly immediately stepped in response to our objection.
Yeah, not fast enough, though.
Right. Well, we couldn't. The cat was out of the bag. That's the problem. And Your Honor immediately corrected them, told them they can't do it. But then here's the problem, right? In the jury instructions, Your Honor will talk about if he chooses not to testify, that they can't hold that against him, the Fifth Amendment rights, the indication. And so how are they to square that with the state making a feature of their directs of these witnesses, the fact that he did that very same thing? And I imagine they'll be mentioning that in their closing too, saying that his silence in the face of these individuals after the incident is somehow indicative of guilt. So how are they going to accord all those things in the proper constitutional manner, which does not divest him of...
Well, I did it in my second instruction. I instructed twice, right? Once immediately after the witness said it, and then after the bench conference, I repeated it. And I said, he has a right not to speak to police.
I understand. And again,
Yeah, I'm not, yeah,
Right.
I'm thinking about this. I don't know how
I
the,
get it, Your Honor.
Yep.
And again, any of these things in isolation, say we didn't have our pretrial motion in the EMT piece, then maybe this isn't as devastatingly damaging. It is, and I'd probably make a similar motion, but it may not be as powerful and cumulatively damaging to his constitutional rights, both under the New Hampshire Constitution.
yeah, well, I'm looking at Remick Remick particularly and Nieper, which say that a curative instruction is generally sufficient. Really, the question here is whether it's sufficient in this case. I got to think,
Right.
that's the decision that I have to make.
And I've laid down the situation as I think we all see it. If I think of other aspects to it, I'm sure Your Honor will give me access to the record, but I don't want to belabor the point.
Yeah. Okay, I'll hear from the state.
So, Your Honor, I think you're correct that the case law says that jurors are presumed to follow instructions. A single mention of the defendant's silence to police officers during trial has been found by the Supreme Court, when accompanied by a sufficient instruction by the trial court not to be grounds for a mistrial. I do agree that Your Honor specifically indicated to the jury he does not have an obligation to speak to the police. And I think what has been made clear to the jury over the course of the trial is that there are two separate entities involved. There are the EMTs and there are the police, and they can differentiate the statements made to EMTs and the statements made to police, especially when Your Honor has told them you cannot consider it when it comes to law enforcement. When it comes to police, you can't consider that. But with the EMTs, they recognize that they are acting, not in an official police capacity, and the jurors will be able to separate those two things with the court's proper instruction. I will say that, recognizing the sort of problematic nature this has, and if defense counsel is okay with this, I'm happy to have the court bring the jurors in individually and question them. If they can put that aside, I don't know if they want to draw attention to it in that.
Yeah, this is my concern about saying anything further about it. I think we moved along fairly smoothly from it. I'm sure the defense doesn't agree with that. But
redirect the witness immediately after, Your Honor, and should focus and have him say that was not the reason. The reason I was sitting with him is because he's not free to move out and sort of change the topic.
No. I appreciate Attorney Newkirk's emphasis at the beginning of his argument that he wasn't accusing the state of any sort of prosecutorial misconduct, and I certainly share that. I think you were as surprised and as distressed by it as I was, although you may have done a better job in concealing your response to it. But I was I'm very unhappy with the trooper. Let me leave it. I'll just leave that. It does surprise me, and but
If I could add just two things.
Well, let me just finish. I'm honestly not sure how the earlier remarks cut, which way they cut in terms of whether this remark had prejudicial effect or not. I'm not sure. So I'll hear you on that.
So, again, what Attorney Greco McKeon's argument is that, somehow the jury can differentiate between the EMTs and the police officer. And I'll remind Your Honor about the testimony of the EMTs in this case, and in particular why it would be difficult. Obviously, we made the argument, the legal argument, Your Honor, outside the presence of the jury, that EMTs are, law enforcement adjacent. But what I would say is that the impression of their kinship with law enforcement was further emphasized by the witness in this case, especially, I believe it was Reed, Brian Reed, from Action Ambulance Services, who appeared in a dark blue uniform with a badge. So, and, from these same individuals.
Yeah, it was a.
Right, so the problem, because you got a uniform with a badge.
I just need to state for the record, I didn't see a badge, and he had a patch.
No.
It was an insignia patch.
I think that it's still agreed.
So Judge, he had a patch on his shoulder, he did have a badge on his chest.
Okay.
But I will say, I believe his testimony was, he now works for a different agency. He was not wearing a badge at the time.
That is my recollection.
Okay.
In court, he did wear a shiny badge.
All right.
So again, the problem becomes, and remember, let's take a step back. Attorney Pinkley, in questioning EMT Haberman, at the end in his redirect, said to her, well, you've done thousands of these responses as an EMT, I'm paraphrasing here, thousands of responses as an EMT, but is this, how many times has somebody said that they refuse to incriminate themselves? Just once. Boom. Mic drop. So he is emphasizing this with a great degree of theatricality for the purpose of impacting the jury.
Yeah, I mean, it's probative evidence. It has considerable probative value if it's within the bounds of the Constitution.
Right, but now it's inextricably intertwined with this officer's unconstitutionally permissible mention of his indication of his right to silence and counsel.
All right, anything the state wants to say?
Again, the focus, I don't disagree that we're focusing on the statement to the EMTs, but it's a statement to the EMTs. It's again been made clear that they were there in a life-saving capacity, that they're not involved in the law enforcement investigation. They testified that we come in, we try to save our life, we leave our supplies and go and turn it over to law enforcement.
Yeah, I mean,
I think they can differentiate between
I'll just say this. I have thought a lot about my decision on the
Statement to the EMTs, because I realize it's an important decision. I'm very comfortable with that decision. I think it was the right decision. I think it remains the right decision. This testimony raises the question of whether the instruction I gave is adequate to cure the prejudice. And the earlier statement, again, I remain sort of unclear as to whether the earlier statement adds to that. I'm not sure which way that cuts. I'll consider everybody's arguments. So unless there's anything else that anybody wants to say immediately, we just don't think that the jurors can disconnect those two things the way they might be able to if we did not have the evidence regarding the EMTs. So really, the bottom line is I just can't say with the necessary confidence, the necessary degree of confidence, that the trial will continue to be fair. So I'm granting that motion is granted, and we will put it down. The same bail order, remains. Mr. Kelly will be held preventively. We'll put it down for a status conference, and we'll proceed from there. If there's anything anybody would like to put on the record now, you're very welcome to, but that's my
I
rule.
would just say that I understand in cases like this, they're incredibly serious, incredibly serious for all involved, including the state and the families. I admire and respect your adherence to the rule of law and making sure that the stakes in the trial are not held against Mr. Kelly.
Okay. All right. I thank everybody for your hard work, and we will get something on the calendar, and we'll see you then. Thank you.
All right. We are off the record.
Want to talk about these, or you want?
I'm happy to connect.
Absolutely, yeah. We can do it, it doesn't have to happen today, so whatever.
And I don't think that it would really be fair or possible to expect them to sever what they heard from the trooper this morning, from everything else that they've heard from the EMTs. I just don't think that the jurors can disconnect those two things the way they might be able to if we did not have the evidence regarding the EMTs. So really, the bottom line is I just can't say with the necessary confidence, the necessary degree of confidence, that the trial will continue to be fair. So I'm granting that motion is granted, and we will put it down. The same bail order, remains. Mr. Kelly will be held preventively. We'll put it down for a status conference, and we'll proceed from there. If there's anything anybody would like to put on the record now, you're very welcome to, but that's my
I
rule.
would just say that I understand in cases like this, they're incredibly serious, incredibly serious for all involved, including the state and the families. I admire and respect your adherence to the rule of law and making sure that the stakes in the trial are not held against Mr. Kelly.
Okay. All right. I thank everybody for your hard work, and we will get something on the calendar, and we'll see you then. Thank you.
All right. We are off the record.
Want to talk about these, or you want?
I'm happy to connect.
Absolutely, yeah. We can do it, it doesn't have to happen today, so whatever.
Microphone.
No.
We're talking about picking stuff up.